Premier to start.
Are we good to go?
Yes, we are.
Make us live.
All
Good
set.
afternoon, everyone. Are we live now? Good afternoon, everyone, and I will call this meeting of the Standing Committee on Government Operations to order. Our first order of business is to open the meeting with a prayer. I will ask MLA Martselos to lead us in prayer.
Thank you, Mr. Chair. This prayer is going to be dedicated to all those who helped navigate us through this terrible fire season. That's all the management, cabinet, the ECC department, everyone that helped, all the people that came in to save the communities from this terrible disaster that we went through, and the emotions, the stress, and everything else. We have to be grateful and thankful, and we are not fire experts. We have to be able to be grateful that we came home to a community that's still intact. And Fort Smith was one of the longest ones. It was 5 weeks for us, and it was trying. But you know what? We got through it, and we got to move forward. And with that, I'm going to start the prayer. Creator, we have this false notion that worry is our personal duty, that we're not given proper consideration to that worry until we've fretted about it for a time. We know that foolish thinking, Creator, but we do this without thinking and therefore lies in our constant problems. Please bring to our attention when we need to pray before we start to worry. Let prayer be our first response in any situation so that our worries don't overwhelm us. In the Creator's name, we pray. Amen.
Amen. Thank you for that prayer, Emily Martselos. I will now ask members of the committee to introduce themselves, beginning with those in the room.
Thank you, Mr. Chairman. Richard Jericho, MLA for Tuning and Ability. Let's see.
Kevin O'Reilly, Frame Lake.
Caitlin Cleveland Camlake.
Thank you. I'm Rylund Johnson, MLA for Yellowknife North. We heard from MLA for the Bachelor Peter Martselos and MLA Semler for Nuvik Twin Lakes Sense for Regrets today. That is the committee. With that, we are here today to have a clause-by-clause review of Bill 85, the UN Declaration on the Rights of Indigenous Peoples Implementation Act. This bill is available on the Legislative Assembly website, as well as there are copies in the committee room there. Bill 85 received second reading on March 30th, 2023, and was referred to the Standing Committee on Government Operations for review. Bill 85 follows the calls to action from the Truth and Reconciliation Commission of Canada and calls for justice from the National Inquiry for Missing and Murdered Indigenous Women and Girls, which calls on all levels of government to implement the declaration. Bill 85 is a historic piece of legislation. It is the third of its kind within Canada, following similar legislation in British Columbia and at the federal level throughout the Government of Canada. It is committee's responsibility to review legislation and provide feedback while holding the government accountable. Committee has carefully reviewed Bill 85, soliciting feedback from Indigenous governments, organizations, stakeholders, and the public. In April 2023, committee received a public briefing from the Premier and staff on Bill 85. Between May and July of 2023, committee engaged the public. Committee hosted 6 public meetings in Fort Simpson, Lilikwe, Fort Smith, The Bacha, Yellowknife, Sambake, Tuktoyaktuk, Nuvik, and Delaney. Committee also set out to travel to Hay River, which the Hay River and area Métis Local 51 had also specifically requested when the summer's wildfires disrupted our public engagement plans. Committee held a virtual public briefing with Métis Local 51 instead. About 50 people from across the Northwest Territories participated in these meetings. Committee also sought written submissions on Bill 85. We sent over 100 targeted engagement letters to Indigenous governments, local governments, advocacy associations, and nonprofit organizations. Committee received detailed submissions from the First Nations Child and Family Caring Society, the First Nations Financial Management Board, the City of Yellowknife, Hay River and Area Local Métis Local 51, The Gwich'in Tribal Council also provided a confidential submission to facilitate committee's discussion and review. Committee appreciates everyone who offered their feedback at public meetings and in written submissions. Their participation demonstrates a commitment to promote the inherent rights of Dene, Métis, and Inuit Inuit people in the Northwest Territories. Most participants welcome Bill 85 as a positive step to advance Indigenous people's rights and offered thoughtful ideas to improve the bill, the action plan, and the government of the Northwest Territories' approach to implementing the declaration more generally. The clause-by-clause review today is a result of all this work. The Standing Committee would like to thank all of the Indigenous governments, stakeholders, and the public who informed committee's positions on the bill. I will now invite Premier Caroline Cochrane in her capacity as Minister of Executive and Indigenous Affairs to deliver any opening remarks she may have on Bill 85. And as well, Madam Premier, if you can introduce your staff, I'll turn it over to you. Thank you.
Thank you, Mr. Chair. Quite impressed with your opening comments. A lot of work that committee did, so I thank you for that. I don't think I can top it, but I'll read my opening comments as well. So, Mr. Chair, members of the Standing Committee, I'm pleased to appear before you today to discuss and conduct a clause-by-clause review of Bill 85, the United Nations Declaration on the Rights of Indigenous People Implementation Act. I have with me today as witnesses Mr. Martin Goldie, Secretary to Cabinet, Anne-Marie Guedon, Manager of Indigenous Affairs at the Department of Executive and Indigenous Affairs, and in behind Ali Kincard, my Ministerial Special Advisor. This bill represents an important step forward in advancing one of the priorities of the 19th Legislative Assembly, tabled in this Legislative Assembly back in October 2019, which directed this government to implement the United Nations Declaration on the Rights of Indigenous Peoples. The Government of the Northwest Territories is committed to continuously exploring how the principles of the United Nations Declaration can be implemented within the constitutional framework of Canada, but we wish to be true partners. Partnership in the implementation of the Declaration means taking the time to make sure the voices of Indigenous people are the driving force behind the process. I want to thank the staff who support this committee. Their collaboration with the staff of the Government of the Northwest Territories has been essential to the progress made on this bill. I want to assure the committee that the Government of the Northwest Territories did review the proposed amendments with the Indigenous governments and Indigenous organizations to seek their views and input. Our discussion today on your proposed amendments will be informed by that input. Where there is consensus from Indigenous governments, the Government of the Northwest Territories will be supporting the motions put forward by this committee. Where Indigenous governments disagree with the proposals put forward by this committee, I should note there's only a couple, we will be looking to represent those views, given the unique nature of this legislation and its focus on the rights of Indigenous people. The Government of the Northwest Territories, in implementing the United Nations Declaration, will work together respectfully and follow the lead of Indigenous governments and organizations. We cannot move ahead of the unique aspirations of the Indigenous people of the Northwest Territories. Therefore, it's imperative that the views of Indigenous governments and organizations be carefully considered in reviewing these proposed amendments. The collaboration on the development of the legislation to support the implementation of the Declaration, as well as the work to collaboratively develop the action plan, is just a first step in what will be a long road of implementing the Declaration in the Northwest Territories. We have much work ahead of us, but we have gotten this far by working together, and we will continue to do so as we advance our long-term goal, which is to see the Declaration implemented in the Northwest Territories. Thank you, Mr. Chair. That concludes my opening comments. I'm prepared to answer any questions that members of Standing Committee may have regarding Bill 85. Thank you, Mr. Chair.
Thank you, Madam Premier. Are there any general questions for the Premier on Bill 85 from committee? Emily O'Reilly.
Thanks, Mr. Chair. So, can the Premier tell us which Indigenous governments have not signed the Memorandum of Understanding or who have not, I guess, agreed to support the bill? Thank you.
Thank you, Madam Premier.
Thank you, Mr. Chair. I'll just pass it over to Anne-Marie. Through you, Mr. Chair.
Go ahead, Emily.
Thank you, Mr. Chair. So there are only 3 Indigenous governments who didn't sign on to the MOU and didn't participate directly in helping to develop the legislation through the working group. So I can list them. Those who have not yet signed the MOU, Asho-Dene-Ko First Nation, Akecho-Dene First Nation, though the Yellowknives Dene were present. Bedziata First Nation, Decho First Nation did not. Bedziata did. Dene-Gotene government did. Gwich'in Tribal Council did. IRC did not. The Kasho-Gotene for Good Hope did sign the MOU. Katladiche First Nation also signed the MOU, as did Nahanni Butte Dene First Nation, or Dene Band, North Slave Métis Alliance, Northwest Territories Métis Nation, and Satu Secretariat Incorporated. Salt River First Nation did not, and the Tlicho government did. However, some of those who didn't sign did also participate in the drafting of legislation. So as I said, the only governments who did not participate either in the working group or in signing on the MOU were the Decho, the Akecho, and the Salt River First Nations.
Thank you very much. Any follow-up, Emily O'Reilly?
Yeah, thanks. Yeah, I guess more of a political question then. What are we going to do about this as a government? Thank you.
Madam Premier.
Thank you. So if and when this bill is passed, then the next step with this is to develop a working group. All 3 of these groups are actually invited to the Council Leaders Group. They're invited at any time to take part in the working group. Just because they didn't sign on or didn't take part in this does not mean that they're excluded. It's an open door policy. They're welcome to come in at any time. Thank you, Mr. Chair.
Thank you, Madam Premier. Any further questions from committee? Emily O'Reilly.
Thanks, Mr. Chair. Did I hear Emily Marcellus? Maybe you want to go to her first. Thank you.
Emily Marcellus, do you have a question?
Yes, yeah, thank you, Mr. Chair. I think that there has to be a one-on-one with a couple of these organizations, because I know they're very supportive of UNDRA. There might have been, there was some discussion even in the Fort Smith meeting with one section, I don't know if it was section 49 or I can't remember now, Mr. Chair, but maybe you could just sort of remind me of that. But, yeah, and that might have been why there was no signature here, but I think that we have to reach out to the, for sure with Salt River and some of the ones that, because that's where I'm, you know, I have to be worried about the people here, and the other groups in the Northwest Territories on how important this whole bill will enhance the growth of the Indigenous rights in the territories. And someone, a personal call by a senior manager or even someone, a politician, even yourself, Madam Premier, would be beneficial to ensuring that we reached out. Okay? I know we're very busy and things are very. It was a crazy time, but you know, it's just an idea, and I want to leave that with the chair to see how you feel about that, or have someone do that. Thank you.
Thank you, Emily Marcellus. Madam Premier.
Thank you, Mr. Chair. I just confirmed officials did reach out to the 3 organizations, and I will make a commitment that as the Premier, I'll also reach out to them. I think it's important that that we get as many of them as possible on the working group. Thank you, Mr. Chair. So I agree.
Thank you. Any follow-up or further comments, Emily Marcellus?
Thank you, Mr. Chair. I want to thank the Premier for that commitment. I think, because I know these groups very well, and you know, we were not always. There's always challenges, even with me, even when I was there. You know, with some of the groups, even within the group. So I know there's challenges, but you know, if we mediate through something, there's always a positive outcome. And I've done that through the 4 years that I've been, and learned a lot from each and every person around this table. I don't care which person it was. with some of the things that were brought up, I learned, and so that's how we move forward. Thank you for the commitment, and thank you, Mr. Chair.
Thank you, Emily Martels. Next on the list, I have Emily O'Reilly.
Thanks, Mr. Chair. In the opening remarks from the Premier, she says, where there's consensus from Indigenous governments, GNWT will be supporting the motions put forward by this committee. So can the Premier just explain what's meant here by consensus? So does that mean that if even one Indigenous government objected, the position now is that an amendment's not going to go ahead? I'm just trying to figure out what that word actually means. Thank you.
Thank you, Emily O'Reilly. I just got a message from our clerk saying that the sound is not presently streaming on the live stream. So, committee, we're going to take a short technical break until we get that sorted. Apologies, everyone.
Mr. Chair?
Yeah. Are we good to go?
We can be good. Yes.
All right, I will now resume this meeting. Hopefully our audio is live streaming. Madam Premier, I'll turn it over to you to answer Emily O'Reilly's question on what exactly you meant by consensus in your opening remarks. Thank you.
Thank you, Mr. Chair. I'll start and then I'll turn to Anne-Marie through the chair, if that's okay. So within the Council Leaders Memorandum of Understanding, item number 8, decision making, 8.1 says the NWT Council Leaders shall strive to carry out its decisions by consensus. If consensus is not possible, by majority vote of the members. Although consensus is desired, unanimity on any one issue is not required to advance action on that issue. So in summary, Mr. Chair, it means that majority vote of the members. And I'll turn it to Anne-Marie to expand on that a little bit through you, Mr. Chair.
Go ahead.
Thank you, Mr. Chair. So practically speaking, though, to describe the process of coming to these motions, all materials that were received either from committee or committee staff were immediately shared with the working group of officials and technical experts to be discussed. We had 2 full meetings of the working group to discuss, and there were no dissenting points of view on the motions as we're speaking about them today. So where we're not able to agree with the motion, that is because the working group had a consensus that that was the preference, and none of these were there a differing opinion for these motions. Thank you.
Thank you very much. Any follow-up, Emily O'Reilly?
Thanks, Mr. Chair. Yeah, well, I'm going to ask how GNWT voted on some of these when we get to the appropriate place, because I want to know where government stands on some of these issues, but I'll bring those up when we get to some of the motions perhaps. But one other general question, if I can, Mr. Chair, and that's about what role is there for the regular MLAs in this bill and in the process? Because I don't see any, but I'd be happy to hear what the Premier's views on that are. Thanks, Mr. Chair.
Thank you, Emily O'Reilly. Madam Premier?
Thank you, Mr. Chair. I'm going to start and then I'm going to turn to Martin Goldney for further explanation through you, Mr. Chair. The role of MLAs is the same as it's always been. When things are brought forward, the MLAs have a responsibility to get public input, such as they did with the United Nations Declaration, your work on the road, etc. That kind of work is still in process. There is a clause within here that does, and I can't pick it out right now, that does talk about the roles of the regular members. But on that, while I look for it, I'm going to turn it to Martin Goldney through you, Mr. Chair, to expand on it, with your permission.
Thank you, Madam Premier. Mr. Goldney?
Thank you, Mr. Chair. So once the legislation is in place, we do anticipate focus to quickly turn to getting the work of an implementation plan developed. And that work will include a review of GNWT policies and legislations. It will be, the work planning associated with that will be done in collaboration with Indigenous governments. So we are sure to, or we want to be sure that we are addressing areas of top concern and priority for Indigenous governments, and as capacity allows and resources allows, to tackle what is of key importance to our partners first. That work might lead to changes in GNWT policy fairly quickly. It might lead to suggestions for legislative initiatives and changes there. And that's where we continue to see the work of MLAs being important, that nothing in here will change the processes that is required of the GNWT as it considers significant policy changes or legislative initiatives or brings forward legislation. So there is recognition that those processes already include roles for MLAs for accountability and oversight and review and input, and so that's not expected to change through this process, Mr. Chair.
Thank you, Mr. Golden. Any further questions, comments from committee? Madam Premier, anything to add?
Yeah, if I can, Mr. Chair, I'd said that there was something in here, but I'm not finding it, so I will retract that comment. Thank you, Mr. Chair.
I'm confident MLA O'Reilly will have comments at the time the motion is moved. Are there any further questions or comments from committee members? MLA Jericho.
Thank you, Mr. Chairman, and thank you to the Premier and our staff for being here today. And I know there's a lot of work that's been put into this bill here, and on Bill 85. I just wanted to come back, and you had mentioned that not everybody signed on to this devolution agreement. In your discussions and the leadership, because we're not privileged to that, because you guys or get together and have a meeting with the Circle of Aboriginal Leaders, etc. But can you maybe expand a little bit more on the rationale as to why or why they haven't come on, and in your discussions, can you maybe elaborate on that a little bit? Thank you.
Thank you, Madam Premier.
I will say that, and I can't really speak for all three of them that haven't signed on. I think they should be speaking for themselves, Mr. Chair. But I do know that at least one of them actually does not even look at the government of the Northwest Territories as a legitimate government. So they tend not to attend any of the meetings that we have. They tend to want one-on-one meetings with the federal government. So that's always been an obstacle that we have been trying to address for many years. And in fact, one of the groups that, the one that I'm thinking of, actually, I have had meetings with on a monthly basis for the last 6 months or so to try to get them to come on board with the council leaders and with devolution, Mr. Chair, because I think that there's a misunderstanding in what it is. So I have been working to try to get them to understand what it is and to try to get them to come on board. But some will never recognize us as a legitimate government. Thank you, Mr. Chair.
Thank you, Madam Premier. Any follow-up, MLA Jericho?
Yeah, thank you, Mr. Chairman. Thank you, Premier, for your comments as well. And I just want to just piggyback where my colleague Kevin already mentioned, is that when it comes to voting on this bill amongst the groups, can you maybe expand a little bit more on that? Because we were not there, we're not privileged to that. So anyways, in terms of going ahead with this file on Bill 85, did it go to a motion amongst yourselves and a committee that you guys are working on this bill with the Indigenous governments? Thank you.
Thank you, MLA Jericho. Madam Premier?
Through you, Mr. Chair, I'd like to turn to Anne-Marie, who's familiar with the working committee.
Thank you. Ms. Guidon?
Thank you, Mr. Chair. So the way that the committee worked in order to develop the legislation as well as speak to the motions were it was an open door. Several letters were sent asking every Indigenous government that they wanted to send a representative to help with this work. Those representatives were both to represent the views of their governments, as well as take back and keep them informed. Every time we have a bit of information to discuss or some work or are moving things forward, all the information is sent to all members who have been volunteered or voluntold to participate on the list. And then we're holding monthly meetings where we all get together and talk about what's being proposed. That's to work through the legislation generally. When it came to the motion specifically, we called several, not emergency meetings, but special meetings just to talk through the motions. We brought our perspective, all the Indigenous governments brought their perspective. Generally speaking, everyone was on the same page about which motions were agreeable to and which ones we were not agreeable to. So it really was a work of technical experts and officials talking things through and coming to consensus agreements on the direction to take. Thank you, Mr. Chair.
Thank you. Are there any further comments from committee at this time? Hearing none, does committee agree to proceed to a clause-by-clause review of Bill 85? Someone's going to just have to have their mic on so I can auditorily hear the agreeds. Beautiful. All right. Committee, 1 second while I pull up the clauses. We will defer the title of this bill until the end and begin with consideration of the clauses. Where possible, I will call clauses in groups. Committee, please turn to clause 1, page 6 of the bill. To clause 1, does committee agree? And I will pass it over to MLA Jericon to move motion 1.
Thank you, Mr. Chairman. Mr. Chairman, I move the clause of 1 of Bill 85 be amended, brackets A in subclause brackets 1 by deleting the definition statutory power and statutory power of the decision and substituting the following. Statutory powers of the decision means a power of right conferred by an attachment to making a decision decided on prescribing, brackets A, the legal right, powers, privileges, immunities, duties, and liabilities of a person or entity, or B, bracket B, the eligibility of a person or entity to receive or to continue to receive a benefit or license, whether or not the person or entity is legally entitled to it, but does not include any powers of the right conferred on the territorial court, Supreme Court, or Court of Appeal by deleting subclause, brackets B, deleting subclause brackets 2, period.
Thank you, MLA Jericon. The motion is in order. To the motion.
Question?
MLA O'Reilly.
Thanks, Mr. Chair. Yeah, I think it's important that we just take a little bit of time to try to explain what some of these changes are. The way the bill had been drafted, the ability to share decision-making authority with Indigenous governments would have even included the territorial court, Supreme Court, Court of Appeal, the sort of authority that those bodies have. And of course, the judiciary really should be independent of everyone. So the amendment here is to actually ensure that those bodies continue to be treated as independent, and they'll have the ability to do the things that they need to do in terms of making decisions on legal rights and matters and so on. So that's the purpose of this, was to carve out their authority from the bill itself. So, and I do support that. I think we do need to have an independent judiciary, and that's what this is designed to do. So thanks very much, Mr. Chair.
Thank you. For the motion.
Question?
Question has been called. All those in favor?
Agree.
And those in the room, I'm either going to need a hand will do, or keep your mics on. Motion is carried. Does the Premier concur with this amendment?
Thank you, Mr. Chair. The government of the Northwest Territories has reviewed the proposed amendments with the Indigenous governments. There is consensus to accept the proposed amendments among the Indigenous governments and organizations and the government of the Northwest Territories. Thank you, Mr. Chair.
Thank you, Madam Premier. The Premier concurs with this amendment. Clause 1 is amended. Committee, to Clause 1 as amended, does committee agree?
Agree.
Thank you. To Clause 2, does committee agree? MLA Cleveland will move motion 12.
Thank you, Mr. Chair. Mr. Chair, I move that Bill 85 be amended by adding the following after Clause 2. 2.1, in the event of a conflict or inconsistency between a provision of this Act or the regulations and a provision of the memorandum, the provision of this Act or the regulations prevails to the extent of the conflict or inconsistency. Thank you, Mr. Chair.
Thank you. The motion is in order. To the motion, MLA O'Reilly.
Sorry, thanks, Mr. Chair. Yeah, I guess committee was concerned that even at the time the bill was brought forward, the memorandum of understanding was not a publicly available document. We had to ask for it to be made public. So we didn't even know what was in that document when the bill was tabled in the House at first, second reading. So once committee had a chance to review the MOU, there was some concern about that the MOU could actually be renegotiated, be amended in ways that might be above and beyond what's actually in the legislation itself. So for greater certainty and clarity, committee felt that it was important that the Act and the regulations should take precedence in the event of any conflict, and that's the purpose of this clause, is to ensure that it's the legislation itself and the regulations that will be in force if there's any sort of conflict with the MOU itself. So that's what this is all about. Thanks, Mr. Chair.
Thank you, MLA O'Reilly. To the motion,
Question?
question has been called. All those in favor? All those opposed? The motion is carried. Does the Premier concur with this amendment?
Thank you, Mr. Chair. You're going to get tired of me repeating this all the time, but I think it's important to show that I did bring it to the Indigenous government, so you'll be hearing me repeat this on every motion. The government of the Northwest Territories has reviewed the proposed amendment with Indigenous governments and organizations. There is general consensus that this clause is not necessary as the memorandum is not a legally binding agreement. The GNWT, however, concurs with this amendment. Thank you, Mr. Chair.
Thank you. The Premier concurs with the amendment. Clause 2 is amended. Committee, to Clause 2 as amended, does committee agree?
Agreed.
Agree.
Thank you, committee. To Clause 3 to 6, does committee agree?
Agreed.
Thank you. Clause 7, MLA Jericon.
Thank you, Mr. Chairman. I move that Bill 85 be amended in each of the subclauses 7 brackets 1 and brackets 2 by striking out must table without delay a statement of consistency and substituting must before second reading table a statement of consistency. Thank you, Mr. Chairman.
Thank you, MLA Jericon. The motion is in order. To the motion, MLA O'Reilly.
Yeah, thanks, Mr. Chair. So the bill does a number of things, and one of which is to require that when the government and even private members bring forward bills, that there's a requirement for a statement of consistency with the declaration. There was some issue about the vagueness of when that statement of consistency should be made available to the public and to MLAs. So the way that the bill had been drafted, it was, I think, without delay, but really wasn't very clear as to how quickly that should take place. So this is going to clarify that at second reading, there needs to be that statement of consistency. And I would suggest that it should come actually with first reading. There's no reason why these things should be delayed. If it's important enough to draft legislation, there should be some consideration at the time of the drafting of consistency with the declaration. So in any event, this is to just clarify when that statement is going to be made available. It'll be required now at least at second reading, and I would urge the government to make it available actually at first reading. But the bill, if it's amended, will make it clear that it's at second reading that it's required. Thank you.
Thank you. To the motion? Question has been called. All those in favor? All those opposed? The motion is carried. Does the Premier concur with this amendment?
Thank you, Mr. Chair. I'm sorry I made this commitment. The government of the Northwest Territory has reviewed the proposed amendment with Indigenous governments and organizations. There is consensus to accept the proposed amendment amongst the Indigenous governments and organizations and the government of the Northwest Territories. Thank you, Mr. Chair.
Thank you, Madam Premier. The Premier concurs with amendment. Clause 7 is amended. Committee to Clause 7 as amended. Does committee agree?
Agreed.
Thank you. Committee, Clause 8, Emily Cleveland.
Thank you, Mr. Chair. Mr. Chair, I move that Bill 85 be amended by deleting subclause 8 brackets 2 and substituting the following. Brackets 2, the Action Plan Committee must be comprised of brackets A, members appointed by Indigenous governments or organizations of the Northwest Territories, brackets B, members appointed by the Government of the Northwest Territories, and bracket C, subject to subsection brackets 2.1, one member appointed by motion of the Standing Committee on Accountability and Oversight or any successor committee that may be established by the Legislative Assembly. Brackets 2.1, the Action Plan Committee may, in respect of a member appointed under paragraph brackets 2, bracket C, limit or specify, brackets A, the classes of persons eligible for appointment, and brackets B, the rights of participation of the member in the work of the Action Plan Committee. Thank you, Mr. Chair.
Thank you, Emily Cleveland. The motion is in the order. To the motion. Emily O'Reilly.
Yeah, thanks, Mr. Chair. I guess I'd like to ask the Premier a question, if I could, about why there's no role for the regular MLAs in the Action Plan Committee itself. And the reason why I ask this is, this Action Plan Committee is really, has the potential to redefine the work and business of the next Legislative Assembly in terms of what policies, legislation is going to be reviewed for consistency with the declaration, but also what legislation can and should be brought forward in the House. And I would have thought that, regular MLAs should at least have some understanding of all of that and perhaps maybe even a little bit of a say in all of that. So why is it that the bill as drafted really didn't make any provision for regular MLAs to have even observer status or the ability to be part of this Action Plan Committee? And maybe some of this is just not understanding the difference between the legislative and executive branches of government. But why was the bill drafted without any involvement of the regular MLAs in the development of the action plan? Thank you.
Thank you, Emily O'Reilly. Madam Premier.
Thank you, Mr. Chair. Anytime there's a legislative act that's put forward, the regular members do have a process within that. The executive is in charge of day-to-day operations with the Assembly. We try to work with regular members as much as possible. This one, we didn't, I gave direction from the very beginning that I would stand behind the Indigenous governments on this. Even when MLAs pushed me to get it done before, I worked with them for many years to try to get this done. So we brought it forward to them, and the Indigenous governments did not like that idea. They felt that this act is about them. It's the United Nations Declaration for Indigenous Peoples. They are the organizations, the Indigenous governments that represent the Indigenous peoples, and they felt that this had to be a process that was done with them alone. They did not see a place for the regular members. Did you want to expand on that, or are you okay with that? Thank you, Mr. Chair.
Thank you, Madam Premier. Any further questions? Emily O'Reilly?
Yeah, thanks. Well, I guess if I can paraphrase, then the position of the cabinet and government was that the regular MLA should have some involvement in the implementation or the action plan committee, and that's good to hear. But if that's not the case, then I'd like the Premier to correct my understanding of that. But in the absence of any, and you know, this clause that's on the table now for discussion is really, has been framed in a way that the action plan committee itself would define who would participate in from regular MLAs, whether it should be a representative or an elected member, and also what kind of participation that would mean, whether it would be simply observer status or an active participant or whatever. So the action plan committee itself would define how regular MLAs would be represented and how they would participate. So I don't really understand why there's a reluctance to, maybe it's just a misunderstanding of the separation between, because the executive, the cabinet, does not represent the regular MLAs. If this action plan committee, I think it has the potential to significantly change the business in the next assembly in terms of what bills are brought forward, what policies are reviewed, the money that's needed to do that work. Those are going to be very, very significant changes. And if the regular MLAs are not part of that, they're only going to be left to review things on a case-by-case basis, which is the case now. And I don't think that that's the way we can and should operate. And I don't think it's in keeping with our own process conventions. You know, our own process convention, I'm going to quote something here, it is fundamental to consensus government that standing committees are provided with an opportunity to review proposed policy initiatives and provide advice to the government in advance of cabinet decisions. So in the absence of this, you know, being accepted by cabinet, how are you going to keep the regular MLAs informed? Because they can't be involved in this action plan committee. How are you going to keep us informed of this? Because I don't feel I was informed very well on the development of this bill, let alone how are you going to do it in the next assembly. But how are you going to comply with the process convention and keep regular MLAs involved and informed? Thank you.
Thank you, Emily O'Reilly. Madam Premier?
Thank you, Mr. Chair. I'm going to turn that to Martin Goldney for reply through you, Mr. Chair.
Mr. Golden?
Thank you, Mr. Chair. And I think what needs to be remembered is that we are not anticipating the work and the process conventions and the roles of MLAs to change. What will change is there will be conversations with Indigenous governments through a formal structure with their representatives and GNWT officials, so we can learn what their priorities and interests are and have the benefit of some shared discussion around how we might better reflect in our policies and our laws the principles of UNDRIP. And once that happens, those same process conventions, when those things are being considered by the GNWT, will continue to apply, and notice will still have to be given, and there will still be processes that will have to consider MLA review and input. And maybe the only other thing I'll add is we did hear this from Indigenous governments where there is some discomfort with setting an expectation for MLA involvement in this work. What we've heard in part has been what's being really described, the role of the Action Plan Committee is to do some of that work planning and provide a space for some of those discussions. And it is going to be very much officials getting together. Having an elected official in the room is There was some concern from our Indigenous government partners that potentially changes the dynamic of how that work is expected to unfold, and some discomfort with that, and even the idea that we'd be changing what was expected to be an officials process with Indigenous governments and the GNWT, the executive branch of the GNWT. So thank you, Mr. Chair.
Thank you, Mr. Goldney. To the motion.
Mr. Chair, I have a comment.
Go ahead, Emily Marcellus.
Mr. Chair, I just want to kind of highlight a discrepancy in this whole area, because I know that the Action Plan Committee is made up of mostly legal lawyers. Okay, it's not the actual leadership sitting at the table and being part of that action plan. And what's happening is there's a disconnect there that is kind of scary. Okay? And if you had someone from the ordinary members that is able to pick up on that has the experience in the next assembly or future assemblies, and we have to look overall of the future. Because lots of times decisions are made for today, and there's consequences in the future. And when that happens, we're basing this on people who do not live here most of the time, this Action Plan Committee, and misinterpretations from the leadership could happen. Okay, I'm worried about the actual leadership in the NWT, because I was the leader for 14 years, and direction to the lawyers is very consequential to how you're going to manage a file. And lawyers can be overwhelming sometimes. I never let that happen to me because I was very strong. And I don't want any consequences from there's not someone sitting there, even from the ordinary membership, when at least to point out that this, and make it known, whether it be to the other ordinary MLAs or to leadership, that this is not the right thing. Even if they're an ex officio member, they don't have to be a voting member. They don't have to say anything, but there has to be a process, because when you're dealing with lawyers, and I've dealt with many those 14 years, and a lot of them were working on my behalf, but it was with clear direction and very much clarity. Because consequences for bad decisions are always there. And it has to come from the leadership and the people that are running that organization. And I'm just wondering if that has been taken into account. And I just want to hear from someone to tell me that these are the things you got to think about, because I was there. I was there all the way. And even with, we still don't have the full implementation of the claim over at Salt River. It takes forever. With one little clause or one little sentence or one word, and it's really puzzling to me. And we're going to go and we're doing this, but I want to know who makes up the action plan. Who are the actual people? I have never been told that. I want to know how the connection between them and the actual leadership and the ideas of that leadership are taking place. I know this is on the 11th hour, but we say we don't concur with that, but and they would not concur with that, of course. That's another bureaucracy again. So those are my views. I'm not going to say I'm going to vote against it, But I want to be very clear that those things have got to be thought about, because I know what I went through in the 14 years when I was with the First Nation, and especially when it comes to lawyers. Thank you, Mr. Chair.
Thank you, Emily Marcellos. Madam Premier, any comment?
Thank you, Mr. Chair. Absolutely, I hear what the MLA, the member, is speaking about. I'm not going to state much more on that. Although I do, if you look at the Act, it does say that the Indigenous organizations and governments will be part of this working group. They can delegate as appropriate. If they delegate, then I expect that there's accountability and oversight on their behalf. I know that I can't speak for them, but I can speak for myself that no official goes forward to any of the work that I'm doing and without clear direction and clear reporting back. So I would expect that from all of the Indigenous leaders as well. I also know, Mr. Chair, that some Indigenous leaders do give leeway to their officials, and some of them are very hands-on. So my gut is telling me that this will probably be a mixed group with leaders and officials, depending on what the Indigenous government and the Indigenous organization wishes. Thank you, Mr. Chair.
Thank you. Members to the motion? Emily Jaragon.
Thank you, Mr. Chairman. I just want to only add a couple of comments as well in regards to what my colleagues are saying as well. When we talk about, consensus government, sometimes it's just a word, because, I feel sometimes that, we say that we're going to be working together and that kind of thing, but sometimes it doesn't happen that way. And I hear what my colleagues are saying, and, the thing is that, the process in terms of moving forward on a document like this is, we got to build relationships and trust, and what I'm hearing from you as well at the same time is that we are, some Indigenous governments are working directly with Government Canada, and there's a reason for that, because they lost faith in our own government, and, we can't even get claims done. We say we're going to do certain things and we don't follow through, etc. But to me, we got to really change the way we do business. And when I hear that, MLAs are left out from the circle of Aboriginal leaders, and maybe from what I'm hearing from you is that, well, if the MLAs are there, they're elected, then there's some concerns there. Well, then at the same time, when I hear after the fact about issues or say in housing or whatever happens on those committees, it really undermines our role as MLAs. And I'm a little bit concerned about that. But going forward, though, this is, to me, is if we did this, consultation and accommodation properly, even though we have 4 years to do it, we probably would have had more people coming on board. But again, it comes down to the trust issue and relationship, and I don't see it. I'm talking as a former leader as well, and I have my ears on the ground, up and down the valley, even though we don't recognize the Dene Nation. But you got to remember the Dene Nation too, as well as the one that created the claimant groups up here in the north. I have a long relationship, and especially when we talk about treaties, and even when we have an oath, we all say that we're going to uphold those treaties, including you as a premier and all the MLAs. We can't forget about that. It's important. So for me, when I think about sometimes when I'm sitting here representing my constituency, but yet at the same time, my hands are tied because I feel that I'm undermined because we don't have a say. We can't get involved in that process. So how are we going to build consensus government if we can't even work together in committee? And so here today, we got some important bills going through towards the end of our term, but again, it's going to come down to trust and relationship. And I just want to maybe make those comments, Mussy.
Thank you, Emily Jaragon. Madam Premier.
Thank you, Mr. Chair. I hear the members. Yeah, but, I mean, how do regular members get represented on these things is by electing their executive. It's regular members that decide which members shall represent them in the executive and oversee government. And that's a process that has its own rules and regulations. I mean, often there's previous governments, they had midterm evaluations. There was members that were put on the table to be taken out. There's accountability processes that we have in the Legislative Assembly to make sure that the executive does represent the interests of members. And if not, then it's an obligation of the regular members to address that as well. I think that within this one, I mean, the Indigenous governments were saying, no, they don't want it in the Act. However, not everything has to be in an Act that has to work with that. I know that there is no Act around the Council of Leaders. It was a table that I did under my own direction. And yet, when we started the committee, I think it was called the Special Committee on Reconciliation and Indigenous Affairs, there was a request, and it wasn't in no Act, it's not in the MOU for the Council of Leaders, that a regular member would be able to come and observe, and they were okay with that. So I think that, you know, if this is something the regular members want, then Indigenous governments are saying they don't want it in an Act. But I see no harm once it's enacted and actually sending a letter again, if you have a committee, to ask that. They just don't want it in the Act. Thank you, Mr. Chair.
Thank you, Madam Premier. To the motion.
Mr. Chair.
Emily
I just wanna
Marcellus.
make a comment. Mr. Chair, I just want for clarity, I'm not questioning the abilities of Cabinet at all, for clarity, okay? I'm questioning the Action Committee and the makeup of the Action Committee, okay? Because not always, not all leaders have the time and whatever to ensure that the Action Committee person that is representing them, who is probably a lawyer, all lawyers and groups that are in this group here, and it's not always clear for them, and they don't have clear direction, and they could be doing things that, and there should be a bit of oversight. If it's not by the ordinary members, it's got to be by somebody, okay? Because you know, we are part of elected people, and we're doing this for the elected Indigenous groups. That's what we're doing it for. And I'm not questioning the ability of the Action Committee either. Maybe everything's above board. I don't know, because I haven't had enough information on their criteria and their mandate from the leadership. I sat with that leadership for 14 years. And I just want to make sure that they actually hear what we have to say, because I feel that I was part of them many times, you know, even in this last 4 years. Because it's crucial that we do pass this bill, and I will be supporting it. But we got to make sure that there's no loopholes for going back on what we really believe in. And that's, for clarity, that's all I want to say. I'm not questioning the abilities of our government, because I know what works, and I know that I was able to navigate the mandate for the community of Fort Smith always. And I just want to make sure that we don't have any loopholes when it comes to something as important as Bill 85. Thank you, Mr. Chair.
Thank you, Emily Marcellus. Any comment, Madam Premier?
Thank you, Mr. Chair. Within the Act, the proposed Act, it says the Action Plan Committee must be comprised of members appointed by Indigenous governments or organizations of the Northwest Territories and the government of the NWT. So we're not telling them within the Act that they have to have officials or chiefs or board chairs. We're allowing them to appoint whatever member they feel is the right person for their organization. I do again think that would be inappropriate to tell them who they can and can't have. Section 10 does talk about the action plan referred to in Section 9 must be prepared and implemented in collaboration and cooperation with Indigenous governments or organizations through the Action Plan Committee, which to me is saying that they need to be accountable for it. It talks about in section 10.2, it must be transparent how the actions are carried out, clear timelines and objectives to assure accountability, a process or measures to review, provisions to require the review and development of amendments to the action plan and other measures or processes that may be described. So I think the Act does outline the responsibilities to Indigenous governments, Mr. Chair. I do think it would be inappropriate for me as the Premier to tell Indigenous governments who they need to appoint to that committee. They can appoint themselves, or they can appoint an official. And my working with these groups is that some will choose to represent themselves and others will choose an official. Thank you, Mr. Chair.
Thank you, Madam Premier. To the motion. Mike Cleveland.
Thank you very much, Mr. Chair. Sitting and listening to my colleagues and also just kind of recalling the long conversations we've had about this one in particular in committee as well. I just wanted to kind of touch on some points of this proposed amendment that committee brought forward. And we did have a lot of conversations in committee about the power imbalance that the Premier referenced and concerns about wanting to ensure that the proposal that we were bringing forward didn't jeopardize the good work that we anticipate seeing come from this committee. And so that's why in the proposed amendment, we did have a section of that clause under brackets 2.1, brackets A, where the Action Plan Committee would not only be able to identify who committee could appoint. So for example, if it turned out that the Action Plan Committee was predominantly, because we're making assumptions on who is going to be there. But if the Action Plan Committee was predominantly made up of staff members, that whoever the future AOC is could then appoint somebody who was not maybe an elected official, but could actually identify somebody from, it could be a community member that committee agreed on, it could be, you know, a past MLA, something like that, where there was an agreement ahead of time that the Action Plan Committee could actually say, we don't want you to send an MLA, but you can send a staff member or whoever. And then part B of that also identifies that the Action Plan Committee would also be able to stipulate the rights of participation of that member in the work of the Action Plan Committee, so that really the Action Plan Committee would be in control of identifying, okay, is that person there as a spectator? Are they able to speak at all? And so committee really did want to respect those positions of Indigenous governments in drafting of this bill, but ensure that the role of the MLA and also the window into what was happening in that work was also available to members. So I just wanted to kind of point out that power imbalance was reflected in committee, and committee was hoping that piece of this proposed amendment would also satisfy those concerns as well. I think too that there are nuanced differences between all of the ridings that we represent, and we are lucky enough on this side of the house as well to have members who are past chiefs of their communities that brought a really valuable perspective in doing this work as well. And then when, you know, at the other end of this at the other end of the spectrum, I am an MLA and represent people who may not live in their traditional territory and who come to me with concerns and are still Indigenous people who live in this territory whose voices need to be heard. And so their concerns are, how are my voices heard through my MLA if I don't have somebody that either has been appointed, or if it's not, if, you know, say MLA Jericon was going to sit at the table, if this was approved and that was what was decided was okay by the Action Plan Committee, how do I ensure that I have somebody that I can pass that on to within the work that I'm doing to ensure that the voices of my constituents are heard? And to that point as well, it's not lost on me that this act was really developed, and then this potentially action plan committee is going to develop an action plan without the voices of the Inuvialuit, without the voices of Inuit people, because IRC has not signed on, right? Did they sign on in the end? Because that's a huge concern of mine, is ensuring that if IRC has not signed on, how are the voices of IRC included in this action plan committee. So I want to make sure that is very clear in kind of ensuring that this is full circle. So if that can be confirmed as well, please. Thank you, Mr. Chair.
Thank you, Madam.
Thank you, Mr. Chair. My understanding is that the Inuvialuit Regional Corporation didn't sign on to the memorandum of understanding, but they were part of the working group that developed the legislative act, proposed legislative act. So do they need both? I'm not so sure. So they were part of the commitment. So Inuit people are represented, Inuvialuit people are represented throughout. As for, again, the comment about having a regular member on the action plan review, I think maybe, Mr. Chair, I mean, for one, this is an act that is being enacted. It's got to take a review after 5 years, I believe. There probably may be some changes. Can look at those things again. But I kind of reflect on what the government does. And I go back to MLAs elect the Executive Council to make sure that they provide the oversight for departments, because we're all responsible for departments within a consensus agreement. When we enact other legislation and other regulations, there's not a regular member that sits on every department. There's not a regular member that sits on every group that's being held within the GNWT. So I think, Mr. Chair, if the regular member is feeling that they're not being represented in this, then they have to look back and say, am I represented in any department? There are processes for that. If an MLA has issues about any department, they are supposed to contact the minister to get clarification, to express their concerns. But if they want, if the MLAs feel that they need to be part on every single action group that's happening in the Legislative Assembly, then we need to look at rewriting how we operate as an assembly, because you don't do that currently with all departments or all acts. So thank you, Mr. Chair.
Thank you, Madam Premier. To the motion.
Question?
Question has been called. All those in favor? Someone needs to raise their hand. Thank you. The motion has been carried. Does the Premier concur?
And I agree.
Oh, back to me. Thank you, Mr. Chair. The Government of the Northwest Territories had an opportunity to review the proposed amendment with the Indigenous governments and organizations. There was general consensus among the Indigenous governments and organizations that they do not support this amendment. Given the nature of the amendment and the sensitivity around the negotiation process, the Government of the Northwest Territories will not support this amendment. Thank you, Mr. Chair.
Thank you. The Premier does not concur. This amendment will not take effect as a result. Committee to Clause 9. Jericho.
Thank you, Mr. Chairman. I move that Bill 85 be amended by adding the following after subclause 9, brackets 2, brackets 3. The minister shall ensure that there is an opportunity for public engagement on the action plan developed under subsection brackets 1. Brackets 4, the minister shall without delay make the action plan developed under subsection brackets 1 publicly available. Brackets 8, by publishing it on a website maintained by the department responsible for the administration of this act, and brackets B, by any other means by the minister considered to be appropriate. Thank you, Mr. Chairman.
Thank you, MLA Jericho. The motion is in order. To the motion, MLA O'Reilly.
Yeah, thanks, Mr. Chair. So what this amendment will do is add, so the bill is drafted. There was nothing in the bill about whether the public would have any role in the action plan itself, reviewing it, an opportunity to comment on it. There's nothing in the bill about whether it would even be made public. I'm not sure how the bill could get developed this far without any of that being sorted out. This isn't even consistent with the government's cabinet's own open government policy. So I don't know how it got to this place, but What these amendments do is say that there will be an opportunity for the public to be engaged in the development of the plan, and I think that's a good thing. And secondly, that the plan itself will actually be made public. There's a requirement that that will happen now. But as I said, I just don't understand how we could get this far with a bill without Cabinet actually implementing its own open government policy. But I do strongly support this amendment, and I wish it had been incorporated into the bill in the first place. But here we are, and this is the kind of role that a committee can play in making sure that these kinds of things get added to legislation when Cabinet can't or won't do it. Thanks, Mr. Chair.
Thank you, Emily O'Reilly. To the motion.
Question.
Question.
Question has been called. All those in favor?
Agree.
All those opposed? The motion is carried. Does the Premier concur with this amendment?
Thank you, Mr. Chair. The government of the Northwest Territories has reviewed the proposed amendment with the Indigenous governments and organizations. Some Indigenous governments and organizations feel that pursuing engagement from the public risks sidelining the Indigenous voices in a manner that undermines the purposes of the proposed act. The GNWT is willing to implement public engagement prior to the publication of the action plan in accordance with the GNWT policies. There is consensus to accept the proposed amendments amongst the Indigenous governments and organizations and the government of the Northwest Territories. Thank you, Mr. Chair.
Thank you. The Premier concurs with the amendment to Clause 9. That Clause 9 is amendment to Clause 9 as amended. Does the committee agree?
Agreed.
Thank you. Clause 10, Emily.
Thank you, Mr. Chair. Mr. Chair, I move that subclause 10, brackets 2 of Bill 85 be amended by brackets A, deleting quote, semicolon, and end quote, at the end of the English version of paragraph brackets D and substituting a semicolon and brackets B, adding the following after paragraph brackets D. Brackets D, point 1, a mechanism for oversight of the implementation of the action plan, and. Thank you, Mr. Chair.
Thank you, Emily Cleveland. The motion is in order. To the motion, Emily O'Reilly.
Thanks, Mr. Chair. Yeah, so when committee reviewed the bill, it's clear that the Action Plan Committee is going to have a central role in developing the work that must take place to review and GNWT policies, legislation, and how that's going to be done, setting priorities and so on. But there is really nothing in the bill itself that talks about whether there should be anyone independent or any sort of oversight of the implementation of the action plan once it's developed. And so the committee felt that it was important that the action plan should contain some consideration of a mechanism for oversight, and that's the purpose of adding this in. It's not to take anything away from the work that needs to be done, but just suggest that while you're preparing that plan, you should start to think about what sort of oversight that there should be in place to ensure that it's actually implemented. And that's the purpose of this section or this addition. Thanks, Mr. Chair.
Thank you, Emily O'Reilly. To the motion.
Question.
Question has been called. All those in favor?
Agree.
All those opposed? The motion is carried. Does the Premier concur with this amendment?
Thank you, Mr. Chair. The government of the Northwest Territories reviewed the proposed amendment with Indigenous governments and organizations. There is consensus to accept the proposed amendment. Thank you, Mr. Chair.
Thank you, Madam Premier. The Premier has concurred with the amendment. Clause 10 is amended. Committee to Clause 10 as amended. Does committee agree?
Agreed.
Thank you. Clause 11, Emily Jericon.
Thank you, Mr. Chairman. I move that subclause 11, brackets 1 of Bill 85 be amended by deleting after the end of each fiscal year and substituting within 90 days after the end of each fiscal year. Thank you, Mr. Chairman.
Thank you, Emily Jarracon. The motion is in order. To the motion, Emily O'Reilly.
Thanks, Mr. Chair. So what this amendment would do is actually put in place a deadline for the annual report that's to be prepared about the implementation of the declaration. So the bill itself just said that there would be an annual report after each fiscal year, but didn't say when. So committee felt that it was important to actually have a deadline in here, and that's the purpose of doing this, so that people can work to that deadline and make sure that the annual report's out there, and then citizens can understand better what's happening with the implementation of the declaration. Thanks, Mr. Chair.
Thank you, Emily O'Reilly. To the motion.
Question.
Question has been called. All those in favor? All those opposed? The motion is carried. Does the Premier concur with this amendment?
Thank you, Mr. Chair. The GNWT has reviewed the proposed amendment with the Indigenous governments and organizations. There is consensus to accept the proposed amendment amongst the Indigenous governments and organizations and the GNWT. Thank you, Mr. Chair.
Thank you, Madam Premier. The Premier concurs with this amendment. Clause 11 is amended. Committee to Clause 11 as amended. Does the committee agree?
Agree.
Thank you. Is there another motion to amend Clause 11 here? MLA Cleveland.
Thank you, Mr. Chair. Mr. Chair, I move that Bill 85 be amended by deleting subclauses 11 brackets 3 and brackets 4 and substituting the following. Brackets 3, the minister shall, upon completion of the report under subsection brackets 1, brackets A, make the report publicly available by publishing it on a website maintained by the department responsible for the administration of this act and table the report before the Legislative Assembly at the earliest opportunity. Thank you, Mr. Chair.
Thank you, Emily Cleveland. The motion is in order. To the motion, MLA O'Reilly.
Thanks, Mr. Chair. So the way that the bill had been drafted, the annual report would be made public within 30 days of it being prepared, but there was no end date. We dealt with that in the last motion, but the report is to be tabled in the House, but the report was also going to be filed with the clerk of the Legislative Assembly, which seemed to be a bit of an anomaly to committee. Usually reports from statutory officers are filed with the speaker, not the clerk. So it was felt that that should be corrected. And I guess the other issue for committee was, making sure that the report is released on a timely basis. So in between sittings, this will now allow for the department to post the annual report, the minister, I should say, to post the annual report to a website. So we don't have to wait for the next sitting of the assembly before it's made public. So people can see the report more quickly. And I think that's the purpose of this, is to clarify the way in which the document will be made public and the timing of that and so on. So it's to really clarify that process. Thanks, Mr. Chair.
Thank you. To the motion.
Question.
Question has been called. All those in favor?
Agree.
Motion is carried. Does the Premier concur with this amendment?
Thank you, Mr. Chair. The GNWT has reviewed the proposed amendment with the Indigenous governments and organizations. There is consensus to accept the proposed amendment among the Indigenous governments and organizations and the GNWT. Thank you, Mr. Chair.
Thank you. The Premier concurs with this amendment. Clause 11 is amended. Committee to Clause 11 as amended. Does committee agree?
Agreed.
Agree.
Thank you. Clause 12, MLA Jarracon.
Thank you, Mr. Chairman. I move that Bill 85 be amended by adding the following after clause 12 brackets 2, brackets 2.1. Before entering into an agreement under this section, a minister authorized under subsection brackets 1 shall provide notice to and seek comments from the Standing Committee of Accountability and Oversight or any successor committee that may be established by the Legislative Assembly. Thank you, Mr. Chairman.
Thank you. The motion is in order to the motion. MLA O'Reilly.
Thanks, Mr. Chair. So the act or the bill provides for ministers to be authorized to negotiate shared decision-making agreements with Indigenous governments, which in itself is probably a good thing. But I am concerned about the scope of these agreements and how broad they could be. And maybe I could just ask a question of the Premier, if I could. What kind of sort of areas could possibly be negotiated here? You know, theoretically, I guess we could negotiate away the Legislative Assembly and Executive Council Act and share that decision-making with Indigenous governments, which is really amounts to constitutional change. So, and all of that without any involvement from regular MLAs or even the public for that matter. So what is the scope of these agreements and how far could they reach, and why is there no provision for regular, so I'll just leave it at that now, Mr. Chair, just the scope of these agreements and how broad they could be and whether they really amount to possibly backdoor constitutional change. Thank you, Mr. Chair.
Thank you, Emily O'Reilly. Madam.
Thank you, Mr. Chair. I'm going to start and then I'll turn it to Martin Goldney for examples. It was kind of an interesting process doing this proposed act on the United Nations Declaration for Indigenous People. At first, the Council of Leaders was very adamant they didn't want to have the BC model. They wanted it totally different, made in the North, for the North, by the North, which I agree with. And then when it came to reviewing them, they'd seen that this clause was in the BC Act, and they wanted it in that act. So we had many discussions around that. It's not for all powers, it's statutory powers alone. But within that, the answer of examples, I'm going to turn it to Martin Goldney with your permission, Mr. Chair, to give examples. But thank you, Mr. Chair.
Thank you, Mr. Gold.
Thank you, Mr. Chair. So we do anticipate this being exercised where there are decisions of a minister that an Indigenous government feel should require more approval from themselves because it might affect their rights and interest in a particular way. So you can imagine that there might be authorizations to access resources, for example, might require or might be an area where Indigenous governments will want to pursue some shared decision making. But I think just to be clear, what is anticipated is that before that happens, the minister will have authorization from the Executive Council to negotiate what that sharing could look like. And maybe to address a bit of the concern around constitutional change, I'm confident that that will be part of the conversation when a minister comes forward for a decision. Does this still fit within the constitutional framework? And one of the things that will have to be considered is the ultimate accountability for decisions. Part of our constitutional framework is democratic accountability, and we do have to recognize that it is important for ministers in many cases to maintain that. So it's not, I don't see it as possible that there would be broad sweeping delegation of ministerial authority without discussions about how accountability needs to be maintained and is important. So unfortunately, we don't have a lot of examples in the real world of where this type of decision-making has been shared. There's only one other jurisdiction, and that's British Columbia, that has a provision like this, and still not a lot of examples outside of perhaps forestry authorizations where those have been pursued. But we do think it is going to be active conversations about how broadly it might be applied. And it's may, not shall, so it still will have to be approved. Thank you, Mr. Chair.
Thank you, Mr. Goldney. To the motion. O'Reilly.
Yeah, thanks, Mr. Chair. Okay, well, that's all fine, but there's absolutely no oversight of this whatsoever. Except after the agreement is finished, it's to be published in the NWT Gazette. Well, that's after the fact. I would think that under the existing policy conventions, that there should be an opportunity for regular MLAs to at least know about this and maybe even have a look at a draft before things are finalized, but that's not where the bill goes. So where is the opportunity for any public input from regular MLAs in the bill? Because there isn't any. So why is there no oversight provided for this authority to negotiate these shared decision-making agreements and the agreements themselves? The authority I can probably live with, but the fact that there's no regular MLA oversight or involvement in the process and no ability for the public to know about this until an agreement is reached, I don't think that that's good public policy, quite frankly. But I guess I'd like to hear from our witnesses. Mr. Chair, thank you.
Thank you, Emily O'Reilly. Madam Premier.
Thank you, Mr. Chair. I'm going to start and then I'll turn it to Martin Goldney, with your permission, Mr. Chair. Within the proposed act, 12.1 says, notwithstanding any other enactment for the purpose of reconciliation, a statute of the Northwest Territories or the Executive Council may authorize the minister on behalf of the GNWT to negotiate or enter into an agreement with an Indigenous government organization. So the oversight actually is in the statute of the law, or it's actually within the Executive Council. The minister can't do it without having this approved before. But I'm going to turn it through you, Mr. Chair, to Martin Goldney if he wants to expand on that. Thank you, Mr. Chair.
Mr. Goldney.
Thank you, Mr. Chair. And maybe just to add that it's important to remember that there still is ministerial accountability for their actions. So there would still be that avenue available if there were concerns with decisions that have been made by either the Executive Council or the minister. And perhaps part of the hesitation on making a legislative requirement for engagement with MLAs is owing to the reality that some of these decisions that are going to be discussed with Indigenous governments will involve a balancing of rights and interests, and we are really talking about things that are akin to minority rights when we're talking about the interests of Indigenous governments. So there is a legitimate concern that expanding that discussion to include representatives more broadly, elected representatives more broadly, is not always might not always be appropriate. So I think we've tried to recognize that concern by not introducing a legislative requirement for necessarily all of those discussions. But I don't want to suggest that future executive councils and future ministers won't want to do engagement with MLAs. I think the hesitation from Indigenous governments and perhaps ourselves is putting in a legislative requirement that is going to, around a subject that is going to require a balancing of interests and, quite frankly, a balancing of minority interest and rights. Thank you, Mr. Chair.
Thank you, Mr. Goldney. To the motion. We'll need to say question if we're going to proceed. Mike, can someone say the word question?
Question.
Question has been called. All those in favor? Thank you. The motion has been carried. Does the Premier concur with this amendment?
Thank you, Mr. Chair. The GNWT has had an opportunity to review the proposed amendment with Indigenous governments and organizations. There was general consensus among the Indigenous governments and organizations that they do not support this amendment. These negotiations are joint decision-making agreements and should be carried out between the GNWT and Indigenous governments. It risks undermining the pursuit of reconciliation that this legal tool enables and could negate the central purpose of the proposed act. Therefore, the GNWT will not concur with this amendment. Thank you, Mr. Chair.
Thank you. The Premier has not concurred with the amendment. The amendment will not take effect as a result. Committee to talk Clause 12, Emily Cleveland.
Thank you very much, Mr. Chair. Mr. Chair, I move that Bill 85 be amended by adding the following after subclause 12 brackets 3. Brackets 3.1, the minister shall, without delay, make an agreement entered into under subsection brackets 1 publicly available by publishing it on a website maintained by the department responsible for the administration of this act. Brackets 3.2, the minister shall, without delay, provide notice to the Standing Committee on Accountability and Oversight or any successor committee that may be established by the Legislative Assembly of an authorization provided to a minister by the Executive Council under subsection brackets 1. Thank you, Mr. Chair.
Thank you. The motion is in order. To the motion, Emily O'Reilly.
Thanks, Mr. Chair. So this motion would require that an agreement, once concluded, would be published on a website rather than in the antiquated Northwest Territories Gazette. I'm not sure how many people read the Gazette. It's not really bedtime reading, but at least you'd be able to find these agreements on a website that's maintained by the department. And then secondly, and importantly, at least regular MLAs would get a heads-up notice of a minister receiving authorization to enter into negotiations for shared decision-making. I would note that in BC, that notice is actually public, and I'm not sure why we can only notify regular MLAs, but at least this is, I think, starting to provide a little bit more oversight, dare I say, or at least information sharing. And I would hope that Cabinet, in its wisdom, would find ways to share a draft of the agreements before they're signed off on with regular MLAs so that they could at least know what's happening and have some input possibly into it. It's not a matter of regular MLAs just electing a cabinet and then cabinet goes off and does whatever it wants. That's not accountability and that's not consensus government. But that's what I think I've heard the Premier say here several times. That's not how consensus government is supposed to work. So, and that's without these kinds of ways of working together, and that's what's in the process conventions. That's what committees try to do, is to find ways to implement what's in the policy conventions. In this very important piece of legislation, it's not a regular piece of legislation, and everybody in this room will acknowledge that. So you shouldn't just expect that regular MLAs are going to have some kind of oversight on an ongoing basis. That's why these things should be in the bill itself, because this is very special legislation. In any event, Mr. Chair, I've probably gone on too long, but that's why the committee felt strong enough to include these two bits in here. I wish it had gone further, and I wish that the minister had concurred with the last one, but I can't speak about past decisions. Thank you.
You to the motion. To the motion.
Emily Jericon has a question.
Go ahead, Jericho.
Call it question, sorry. Question.
Question.
Thank you. Question has been called. All those in favor? All those opposed? Thank you. The motion is carried. Does the Premier concur with this amendment?
Thank you, Mr. Chair. I want to start by saying, correction for myself, if I gave the impression that Executive Council gets appointed and then runs free rein without any accountability. That is not my impression of consensus government. I do recognize regular members have oversight of our work all the time. So if I gave that impression, then I apologize. But on this one, the GNWT has reviewed the proposed amendment with Indigenous governments and organizations. There is consensus to accept the requirement to publish the final report on the website. Therefore, we concur with the proposed motion. Thank you, Mr. Chair.
Thank you. The Premier concurs with the amendment. Clause 12 is amended. Committee to Clause 12 as amended. Does committee agree?
Agreed.
Thank you. To Clause 13, MLA Ajarakan.
Chairman, I move that Bill 85 be amended by deleting Clause 13 and substituting the following: 13 brackets 1, a review of this act and its effectiveness shall be conducted no later than 5 years after its coming into force by brackets A, and an independent person or an entity appointed by the Action Plan Committee, or brackets B, if no person or entity is appointed under paragraph brackets A, the Action Plan Committee. Brackets 2, a review conducted under the subsection brackets 1 must include an opportunity for the public engagement. Brackets 3, the results of the review conducted under subsection bracket 1 must be made publicly available on the website, readily available to the public. Thank you, Mr. Chairman.
Thank you, MLA Ajarakan. The motion is in order. Do the motion. MLA O'Reilly.
Thanks, Mr. Chair. So the clause 13 of the bill as drafted just basically says that the action plan committee shall review the act and its effectiveness no later than 5 years after it's coming into force. That's it, period. And I guess committee was of the view, that the action plan committee is going to play a very important role, but I guess we weren't convinced that the committee should be reviewing its own work. And that's what the way the act has been drafted is that the committee would be reviewing its own work. It's just probably not a good idea. So committee felt that it would probably be in everybody's interest to ensure that an independent party would review, in particular, I guess, the implementation of the action plan once it's out there. And in fact, in a previous motion, that's to be part of the action plan consideration, is looking at some way of providing some oversight. So in any event, that's what this does, is provide a process for an independent party to undertake this review, rather than have the action plan committee reviewing its own work. So that's the purpose here. Thanks, Mr. Chair.
Thank you, MLA O'Reilly. To the motion.
Question?
Question has been called. All those in favor? All those opposed? The motion is carried. The Premier concur with this amendment.
Thank you, Mr. Chair. The government of the Northwest Territory has reviewed the proposed amendments with Indigenous governments and organizations. The government of the Northwest Territory concurs with motion 13A as drafted. Thank you, Mr. Chair.
Thank you, committee. Clause 13 is amended. Does committee agree? MLA Cleveland.
Thank you very much, Mr. Chair. Mr. Chair, I move that Bill 85 be amended by deleting subclause 13 brackets 1 and substituting the following: 13 brackets 1, a review of this act and its effectiveness shall be conducted no later than 5 years after its coming into force by an independent person or entity appointed by the Action Plan Committee. Thank you, Mr. Chair.
Thank you. The motion is in order. To the motion. Emily O'Reilly.
Thanks, Mr. Chair. Yeah, I get confused at the best of times, but this would actually require that an independent party conduct the review. The last one, motion that was accepted by the Premier actually allowed for that to be an option. So this would actually create a requirement. And the previous motion as well made sure that there would be an opportunity for public engagement and that the report itself would be public, which is completely absent from the original bill. So in any event, this is about making it a requirement that an independent party carry out the review. Thanks, Mr. Chair.
Thank you. To the motion.
Question?
Question has been called. All those in favor? All those opposed? The motion is carried. Does the Premier concur with this amendment?
Thank you, Mr. Chair. The Government of the Northwest Territories had an opportunity to review the proposed amendments with Indigenous governments and organizations. There was general consensus among the Indigenous governments and organizations that they do not support this amendment. Indigenous governments and organizations prefer that the Action Plan Committee conduct the review and not be obligated to appoint an independent person or entity. Therefore, the GNWT will not support this amendment. Thank you, Mr. Chair.
Thank you, Madam Premier. As the Premier does not occur, this amendment will not take effect as a result. The previous motion stands, which amended Clause 13. So to Clause 13 as amended, does committee agree?
Agree.
Thank you. Clause 14, does committee agree?
Agreed.
Agreed. Awesome. Thank you. Clause 15, Emily Jericho.
Mr. Chairman, I move that Clause 15 of Bill 85 be deleted and the following substituted. 15 brackets 1, the Statutory Instruments Act is amended by this section. Brackets 2, subsection 2 brackets 3 is amended by adding the following after paragraph brackets B. Brackets B, B1. It is consistent with the declaration as defined in subsection 1 brackets 1 of the United Nations Declaration on the Rights of Indigenous People, Implementation Act, and the rights recognized and affirmed under Section 35 of the Constitution Act 1982. Brackets 3, the following is added after subsection 2, brackets 4. Brackets 5, the results of an examination completed under paragraph brackets 3, brackets B1 must be made publicly available on the website readily available to the public. Thank you, Mr. Chairman.
Thank you, Emily Jericho. Motion is in order. To the motion. Emily O'Reilly.
Thanks, Mr. Chair. I'll do my best to try to figure out what this really means. So I think this would mean that if there's something done by cabinet, like a regulation, orders, things like that, that are covered under the Statutory Instruments Act, that there would have to be this statement of consistency with the declaration as there is for legislation earlier in the bill. This would now make that statement of consistency public. I think that's what happens here. Mr. Chair, thank you.
Thank you. To the motion.
Question?
Question has been called. All those in favor? All those opposed? Motion is carried. Does the Premier concur with this amendment?
Thank you, Mr. Chair. The GNWT has reviewed the proposed amendment with Indigenous governments and organizations. There is consensus to concur with the proposed amendment. Thank you, Mr. Chair.
Thank you. The Premier concurs with the amendment. Clause 15 is amended. Committee, to Clause 15 as amended. Does committee agree?
Agree.
Thank you, committee. Does committee agree that Bill 85 of the UN Declaration on the Rights of Indigenous Peoples Implementation Act is now ready for consideration in Committee of the Whole as amended. Emily Cleveland.
Thank you, Mr. Chair. Mr. Chair, I move that Bill 85, United Nations Declaration on the Rights of Indigenous Peoples Implementation Act, be reported to the Assembly as ready for consideration in Committee of the Whole as amended. Thank you, Mr. Chair.
You to the motion. The motion is in order. To the motion.
Question.
Question?
Question has been called. All those in favor?
Agreed.
All those opposed? Motion is carried. Bill 85, the United Nations Declaration on the Rights of Indigenous Peoples Implementation Act will be reported to Assembly as ready for consideration of Committee of the Whole as amended. Thank you to the Premier and staff officials today. Madam Premier, would you like to provide any closing comments?
Thank you, Mr. Chair. I do want to thank committee for the work that they've done on this by taking it on the road. I think it was an important bill. I think it's one of the most important acts that we might be getting through this assembly if passed. And I do think that by working together with the amendments that were proposed, although we didn't accept all, the ones that we did were good amendments. So thank you for your work on this as well. Thank you.
Thank you, and I would like to thank committee for all of their work on this, as well as our staff for all their hard work on the bill, and certainly all the work by Indigenous government organizations and stakeholders and the public for their input and assistance. Thank you, committee. That was a 2-hour but rather efficient clause by clause. Thank you for preparation of all the motions and the work that went into that. This concludes our public portion of our meeting. Emily Cleveland will move us in camera. We will end the public broadcast, and committee, we will take a 10-minute break. Thank you.